constitutional law, but I do thoroughly enjoy it as a hobby. And so I appreciate being provided a pulpit from which to expound on some items hopefully of interest with regard to tonight's topic. And tonight I do plan to talk about what historian Eric Foner, Foner, has referred to as America's second founding. And tonight's focus is going to be on voting rights. Mr. Foner has recently authored a book titled The Second Founding, How the Civil War and Reconstruction Remade the Constitution. And I understand that the Wyomissing Library has this as an audio book. And I recommend it. It's written by a historian, even though it covers legal topics, it's written certainly for non-lawyers. To him, the second founding began with the ratification of the 13th Amendment, which became part of our Constitution in December 1865. It's also been referred to as the first of the three Reconstruction or Civil War amendments to our Constitution. The 13th Amendment provides, and I'll quote from Section 1, neither slavery nor involuntary servitude, except as a punishment for crime, whereof the party shall have been duly convicted, shall exist within the United States or any place subject to their jurisdiction. So under the 13th Amendment, the slaves were now free, at least on paper. But what was the scope of that freedom? Well, the next step in the second founding was the 14th Amendment. And it ultimately provided in its first section, and I will read from it as well, the first sentence, all persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States and of the state wherein they reside. Now that first sentence was really drafted and ratified in response to the United States Supreme Court's 1857 Dred Scott decision, which had held that African Americans were not citizens, not entitled to any rights as being citizens, even though they had been born in the United States. So the first sentence provided for, as we know it today, birthright citizenship by way of the 14th Amendment. Now, the 14th Amendment's first section then continued to provide for a second sentence, and I'll read that then. This is part of the 14th Amendment. No state shall make or enforce any law which shall abridge the privileges or immunities of citizens of the United States, nor shall any state deprive any person of life, liberty, or property without due process of law, nor deny to any person within its jurisdiction the equal protection of the law. That sentence that I just read has been referred to as arguably the most important sentence in the entire Constitution, providing for due process and for equal protection. Its author was Congressman John Bingham, a Republican from the state of Ohio. After the 13th Amendment was ratified, he became a strong advocate for equality between the blacks and the whites. And he argued that that second sentence was needed to, quote, throw the shield of the law of the land over these unfortunate human beings, lately slaves, now emancipated citizens, who with their ancestors have through many generations and many centuries been the victims of cruelty, outrage, oppression, and wrong, close quote. Certainly a noble purpose, but has it succeeded? Back in October, I gave a talk for the Wyomissing Library discussing the Constitution, the Supreme Court, and race. I spent a considerable amount of time on the 14th Amendment and its interpretation by the United States Supreme Court over time, more than since its ratification more than 150 years ago. Tonight, my focus, though, is on the third step of the second founding, and that is the ratification of the 15th Amendment on February 3, 1870. And it provides, in its first section, the right of citizens of the United States to vote shall not be denied or abridged by the United States or by any state on account of race, color, or previous condition of servitude. And then its second section provides very simply, the Congress shall have the power to enforce this article by appropriate legislation. Now, you will note that the amendment here did not actually enfranchise people of color. Rather, it prevents the disenfranchisement of a citizen because of their color. So, how did the South react to the 15th Amendment? Well, Mississippi led the way. A new state constitution was adopted, and it required payment of a poll tax and barred prospective voters when they could not read a section of the state constitution or provide a reasonable interpretation of it. These constitutional or statutory requirements did not mention race at all, race neutral. And in time, African Americans' right to vote was eliminated throughout the old Confederacy, as well as in Oklahoma and Delaware. When voting cases came before the Supreme Court of the United States in the latter 1800s, the 15th Amendment the justices did not invalidate these requirements by virtue of the 15th Amendment. These requirements I'm referring to are similar to what the Mississippi state constitution had imposed. Instead, these requirements were upheld. In each case, the law was viewed as, quote, fair on its face and impartial in appearance, close quote, because the requirements did not mention race at all. The court never looked behind the language of the law or the state constitution to determine the effect of the requirements. 75 years later, on January 23, 1964, the Constitution's 24th Amendment was ratified. It provides that the right of a citizen to vote for president, senator, or House representative cannot be denied due to the failure to pay any poll tax or other tax. That amendment applied to federal elections. And then 2 years later, in 1966, the Supreme Court held in Harper versus Virginia State Board of Elections that poll taxes are unconstitutional for all other elections, including state and local. Such taxes were found to violate the Equal Protection Clause of the 14th Amendment. Also, Congress acted. It passed the Voting Rights Act of 1965 under the authority provided by Section 2 of the 15th Amendment. And you'll recall, as I read it, the Congress shall have the power to enforce this article by appropriate legislation. The law is discussed at some length in the book titled The Case Against the Supreme Court, written by Erwin Chemerinsky. He is a dean and professor of law at the University of California School of Law. And he writes, The Voting Rights Act of 1965 is one of the most important federal laws adopted in my lifetime, according to him. Section 2 of the law prohibits state and local governments from having election practices or systems that discriminate against minority voters. Lawsuits can be brought to enforce it, but Congress believed that this would not be sufficient to stop discrimination in voting. Congress knew that litigation is expensive and time consuming. Congress also knew that Southern states, in particular, had the practice of continually changing their voting systems to disenfranchise minority voters. So, in addition to Section 2, the law provided in its Section 5 that jurisdictions with a history of racial discrimination in voting may change their election systems only if they receive pre-clearance from the Attorney General of the United States or a three-judge federal district court. And such election system changes could include, for example, voter identification laws, drawing new district maps, and restricting early voting. Now, these jurisdictions that were to be covered by Section 5 were set forth by a coverage formula in Section 4B of the Act. And in 1965, when the law was first passed, those jurisdictions included the states of Alabama, Georgia, Louisiana, Mississippi, South Carolina, and Virginia. Also included were 39 counties in North Carolina and one in Arizona. These were jurisdictions maintaining literacy or knowledge tests, or requiring that the voters actually have to meet good moral character requirements, or even the need for references from other registered voters. And these jurisdictions had less than 50% voter registration or turnout in the 1964 presidential election. These covered jurisdictions could obtain pre-clearance only by proving that any proposed change to their election system did not have the effect of denying or abridging the right to vote on account of race or color. The law was held to be constitutional by the Supreme Court in its 1966 South Carolina versus Katzenbach decision. The court found that it was justified in order to address voting discrimination where it persists on a pervasive scale. Sections 4 and 5 requiring pre-clearance by only certain jurisdictions considered extraordinary, certainly were considered extraordinary measures, but justified given the history of discrimination by the covered jurisdictions. Why would Section 2's nationwide provision for allowing for the filing of a lawsuit to bar voter discrimination not be sufficient? Why was it necessary to single out certain jurisdictions for special attention? Well, the Katzenbach court reasoned, and I'll quote from the opinion, voting suits under Section 2 are unusually onerous to prepare, sometimes requiring as many as 6,000 man-hours spent combing through registration records in preparation for trial. Litigation has been exceedingly slow, in part because of the ample opportunities for delay afforded voting officials and others involved in the proceedings. Even when favorable decisions have finally been obtained, some of the states affected have merely switched to discriminatory devices not covered by the federal decrees, or have enacted difficult new tests designed to prolong the existing disparity between white and Negro registration. Alternatively, certain local officials have defied and evaded court orders or have simply closed the registration offices to freeze the voting rolls. And so the court concluded a new approach was needed. And actually, there was success with the pre-clearance procedure. The Justice Department has estimated that in the 5 years after the law's passage, almost as many Blacks registered to vote in Alabama, Mississippi, Georgia, Louisiana, North Carolina, and South Carolina as in the entire country, as in the entire century before 1965. The law was only to be in effect for 5 years, but the law was renewed in 1970, at which time Congress extended pre-clearance coverage to jurisdictions that had a voting test and less than 50% voter registration or turnout as of 1968. That change brought in additional counties in California, New Hampshire, and New York. And then in 1975, it was renewed for 7 years and extended its coverage to jurisdictions that had a practice of providing English-only voting materials in places where over 5% of voting age citizens spoke a single language other than English. And that brought in, as covered jurisdictions, the states of Alaska, Arizona, and Texas, as well as several counties in California, Florida, Michigan, New York, North Carolina, and South Dakota. 7 years later, in 1982, Congress again reauthorized the law, now for 25 years, without changing its coverage formula in Section 4B. President Ronald Reagan signed the reauthorization, and in so doing, he hailed the right to vote as, and I quote, "the crown jewel of American liberties, and we will not see its luster diminished," close quote. So those 24 years passed. And in preparing for its expiration, the law to be expiring in 2007, Dean Chemerinsky notes, once again in the book, The Case Against the Supreme Court, he notes that Congress held 21 hearings and produced a record of almost 16,000 pages in considering whether to extend the law again. Congress documented continued discrimination against minority voters in jurisdictions covered by the pre-clearance requirement. For instance, it found that there were 650 instances between 1982 and 2006 in which pre-clearance was denied to the covered jurisdictions. And I'd like to share with you some of the examples of suggested changes that were deemed to be too discriminatory and were refused. For example, in 1993, the city of Millen, Georgia, proposed to delay the election in a majority Black district by 2 years, leaving that district without representation on the city council, while the neighboring majority white district would have 3 representatives. The Department of Justice blocked that proposal. Well, the county then sought to move a polling place from a predominantly Black neighborhood in the city to an inaccessible location in a predominantly white neighborhood outside city limits. That was blocked as well. In 2001, the mayor and an all-white 5-member board of aldermen in Kilmichael, Mississippi, abruptly canceled the town's election after an unprecedented number of African American candidates announced they were running for office. The Department of Justice required an election, not permitting that change in the system. And as a result, the town elected its first Black mayor and 3 Black aldermen. In 2003, after African Americans won a majority of the seats on the school board for the first time in history in Charleston County, South Carolina, the county proposed an at-large voting mechanism for the board. The proposal was made without consulting any of the African American members of the school board and was found to be an exact replica of an earlier voting scheme that a federal court had determined violated the Voting Rights Act. See what I mean? What I read to you before about how they would just defy a court order or try to get around it in some way? Well, the Department of Justice, invoking Section 5 of the law, blocked that proposal. In 2004, Waller County, Texas, threatened to prosecute 2 Black students after they announced their intention to run for office. The county then attempted to reduce the availability of early voting in that election at polling places near a historically Black university. Proposals that were blocked. And a final example, in 2006, the Supreme Court found that Texas, as part of a lawsuit attempt to redraw a congressional district to reduce the strength of Latino voters, bore, and the court quoted, the mark of intentional discrimination that could give rise to an equal protection violation. And the United States Supreme Court, ordered the district redrawn in compliance with the Voting Rights Act. Well, in response, Texas sought to undermine the court's order by curtailing early voting in the district. But that curtailment was blocked by an action to enforce the pre-clearance requirement. So the dean continues in his book, there likely were thousands of other situations in which covered jurisdictions did not even seek to put plans into place because they knew that they would be denied pre-clearance. Also, there were far more suits for race discrimination in voting that had been successfully brought against jurisdictions covered by Section 5 of the Voting Rights Act. So at the time, in 2006, 2007, that period of time, the House Judiciary Committee chair, a Republican, Representative James Sensenbrenner, he called it, the work of Congress at that time, one of the most extensive considerations of any piece of legislation that the United States Congress had dealt with. Those 21 hearings producing 16,000 pages of evidence. And based upon the evidentiary record developed by that committee, its report concluded that the extensive evidence of continued discrimination clearly showed the continued need for federal oversight in covered jurisdictions. It further reported that without the continuation of the Voting Rights Act of 1965's protections, the significant gains made by minorities in the last 40 years would be undermined. So, the Republican-led House of Representatives responded with a resounding reauthorization vote of 390 to 33. When the United States Senate failed to take up the bill immediately, Representatives Sensenbrenner, the chair of the Judiciary Committee, and the late John Lewis made some, as he would call it, good trouble, and wheeled all 12,000 pages of the committee's report over to the Senate side and dumped it, demanding action. The result was a unanimous approval, reauthorization to the tune of 98 to 0. President George W. Bush signed it into law. In 2009, then, the United States Supreme Court, led by Chief Justice John Roberts, in a decision dealing with an issue of identifying what was a covered jurisdiction or not, expressed serious doubts about the law's continuing constitutionality without addressing them at that time. But in effect, the court was inviting to accept a case in which to act upon those doubts. Here's an interesting, at least an interesting tidbit of fact to me. In 1982, when the Voting Rights Act was up for reauthorization that year, there was a new attorney in the Justice Department, and he was arguing against reauthorizing the Voter Rights Act and was recommending that President Reagan veto the reauthorization bill. That young attorney was John Roberts. President Reagan did not follow the recommendation, but now that attorney is in a higher seat of authority than what he was in 1982. It did not take long for a covered jurisdiction to accept the court's 2009 invitation to consider the Voting Rights Act continuing constitutionality. Shelby County, Alabama, a covered jurisdiction under Section 4 of the law, wanted to make changes in its voting procedures, but they were refused by the Attorney General under Section 5's pre-clearance requirements. Whereupon the county sued the Attorney General, claiming that the law was now unconstitutional. The federal district court, though, upheld the law, finding that the evidence before Congress and presented in 2006 was indeed sufficient to justify reauthorizing Sections 4 and 5 of the Voting Rights Act. The county appealed to the United States Supreme Court. And the court held in a 5-4 decision that Section 4B, the provision that determines which jurisdictions need to get pre-clearance, was unconstitutional. And this had the practical effect of nullifying Section 5 of the Voting Rights Act. Without Section B, there are no state or local governments that need to get pre-clearance. No longer will state or local governments have to receive pre-approval from the Attorney General before changing their election systems, no matter how long or how pernicious their pattern of race discrimination in voting had been in the past. Dean Chemerinsky writes then in his book, "It is the first time since the 19th century that the court has declared unconstitutional a federal civil rights statute concerning race. Chief Justice Roberts wrote for the court and stressed that the formula in Section 4B rested on data from the 1960s and 70s. Congress did not change Section 4B when it extended the law in 2006, but rather kept the formula it had adopted in 1982. Roberts said that times had changed. Race discrimination in voting does not exist as it used to, and some covered jurisdictions had higher registration rates for minority voters than places where pre-clearance is not required. He went on, the court said that it was an intrusion on state and local sovereignty to require that they beseech the Attorney General to approve their election systems. Roberts said, writing for the majority, that it violated a principle of equal state sovereignty to treat the states differently with regard to the requirement for pre-clearance. But there is a problem with that reasoning. You won't find the principle of equal state sovereignty mentioned anywhere in the United States Constitution. Another book, Supreme Inequality by Adam Cohen, has a very good discussion of the Shelby County decision, and I would recommend that book as well. Author Cohen cites Judge Richard Posner of the United States Court of Appeals for the Seventh Circuit. He was appointed to that bench by President Ronald Reagan, and he is considered a prominent conservative. After Shelby was decided, Judge Posner stated flatly, there is no doctrine of equal sovereignty. He went on to say, according to Mr. Cohen, it was a principle of constitutional law of which I had never heard, for the excellent reason that there is no such principle. And Judge Posner concludes, the whole majority opinion in Shelby County rests on air. I submit that that is troubling enough, but I find it just as troubling that Chief Justice Roberts only paid lip service to the congressional record. The majority's problem was with Congress not changing the coverage formula from that what was in 1975. That is, in determining what jurisdictions should be covered by the pre-clearance requirement. And the Chief Justice wrote, and I quote, our country has changed. Congress must ensure that the legislation it passes to remedy that problem speaks to current conditions, close quote. Well, it is true that tremendous progress has been made. There are no more literacy or poll taxes. Voter turnout and registration in the covered jurisdictions now approach parity. And minority candidates hold office at unprecedented levels. We even had an African American serve us as president of the United States. All that is true. But what about the 650 instances since the law was last reauthorized where pre-clearance was denied? 650 suggested changes that would have resulted in voter discrimination, but for the Voting Rights Act. And what about the deterrent effect? Covered jurisdictions not even asking because they knew that the suggested changes they had in mind would be rejected, would be denied. As I said, it was a 5-4 decision, with the more liberal justices being in the minority. And they were led by Justice Ruth Bader Ginsburg, who wrote a 36-page dissenting opinion. She lambasted the majority for ignoring the evidentiary record painstakingly created by the Congress to support reauthorization and not changing the coverage formula. There was no need to change the coverage formula based upon the data that was uncovered by all those hearings, covering more than 15,000 pages of transcript. She wrote, volumes of evidence supported Congress's determination that the prospect of retrogression was real. In a memorable line that many of you probably have seen quoted or were quoted at the time, Justice Ginsburg writes, and I quote, throwing out preclearance when it has worked and is continuing to work to stop discriminatory changes is like throwing away your umbrella in a rainstorm because you're not getting wet. The notorious RBG concludes her opinion as follows. After exhaustive evidence gathering and deliberative process, Congress reauthorized the Voting Rights Act, including the coverage provision, with overwhelming bipartisan support. It was the judgment of Congress that 40 years has not been a sufficient amount of time to eliminate the vestiges of discrimination following nearly 100 years of disregard for the dictates of the 15th Amendment, and to ensure that the right of all citizens to vote is protected as guaranteed by the Constitution. That determination of the body, empowered to enforce the Civil War amendments by appropriate legislation, merits this court's utmost respect. In my judgment, the court errs egregiously by overriding Congress's decision. In his book, Supreme Inequality, Adam Cohen notes that in declaring Section 4B of the Voting Rights Act unconstitutional, the High Court was not merely striking down any act of Congress. And he writes, the court was invalidating a law that was a crowning achievement of the civil rights movement, and one that had won overwhelming bipartisan support in Congress and from presidents for decades. The law also regulated a subject, voting in federal elections, that the Constitution specifically and repeatedly assigned to Congress. Article 1 of the Constitution states that Congress shall regulate the times, places, and manner of federal elections. And the 15th Amendment, which bars racial discrimination in voting, says that Congress shall have the power to enforce this article by appropriate legislation. And he concludes, the senators who heard Roberts say at his confirmation hearing that he intended to be an umpire on the court, simply calling balls and strikes, could not have been expecting a ruling like this. In his book, Dean Chemerinsky writes that he regards Shelby County as among the worst decisions in recent times. And he writes, the consequences will be felt for many years to come as the invalidation of the preclearance requirement in the Voting Rights Act will lead to many more discriminatory election systems, close quote. Justice Ginsburg had another interesting line in her opinion. She quoted Shakespeare. What's past is prologue. And she quoted from George Santayana. Those who cannot remember the past are condemned to repeat it. She has been proven correct. On the very day Shelby County ruling came down, the Texas Attorney General announced that a voter ID bill would immediately go into effect. And the bill provided that it would accept a gun license as a proper ID, but not a student ID. The move had been previously denied under the pre-clearance requirement. Texas then went on to close 750 polling places focused on the fastest growing Black and Latino communities. Voter turnout plunged. By the 2018 election, Texas was 50th of the 50 states in the rate of voter turnout. After Shelby came down, the decision came down, North Carolina rushed to pass what has been described as a, quote, monster suppression package, close quote. It included eliminating half of the early voting days, including Sunday, the most popular day for turnouts at Black churches. Within 24 hours of the ruling, Alabama announced that it would start requiring photo IDs, reviving a plan that had been blocked by the Voting Rights Act. Alabama then went on to announce that it would close 31 driver's license offices where those photo IDs are taken. There was a clear racial pattern to that closing. 8 of the 10 counties with the highest percentages of Black voters lost their offices to have their voter IDs taken, pictures taken. A Pew Charitable Trust report found that 5 years after Shelby County, nearly 1,000 polling places had been closed, many of them in Black communities in the South. In Indiana, the Republican Secretary of State eliminated 170 voting precincts in Lake County, where the state's largest Latino and second largest Black communities were located. Obviously, reducing the number of polling places is an effective way of reducing voter turnout. And as a result of the court's ruling in Shelby, it is happening a lot more. In theory, Congress can overcome the Shelby County decision by passing a new version of Section 4 with a new formula based on contemporary data for determining which jurisdictions need to receive pre-clearances. But the bipartisan atmosphere that we saw existing in 2006 clearly no longer exists. An effort to pass what is now referred to as the John Lewis Voting Rights Advancement Act has been underway. In the last session of Congress, the bill passed the House, but went nowhere in the Republican-controlled Senate. That may change now. As proposed, the John Lewis bill scraps the old basis for pre-clearance and instead applies strict federal oversight to any jurisdiction that has committed repeated voting rights violations in the prior 25 years. And these jurisdictions will be covered then for 10 years. If they establish a clean record moving forward, they can come out of the coverage. And the focus under this proposed law is limited to reviewing changes in voting that have been found to have the greatest discriminatory impact: voter ID laws, closing voting sites, and the reduction of multilingual voting machines. There is also another voting rights bill that is pending in the House of Representatives, and its name is For the People Act. It would establish nationwide automatic voter registration, state-level redistricting commissions, and voting by mail. In effect, the For the People Act would nationalize many of the reforms that the states experimented with during the pandemic. These efforts are at the federal level with a focus on being an expansion and protecting voter rights. At the state level, there is also activity. There, though, in some areas, the focus is quite different, to actually tighten, if not suppress, voting. The New York Times reported on January 31 that state legislators in this country have filed 106 bills to make it more difficult to cast a ballot. And on February 8th, the Reading Eagle reported that Pennsylvania leads the way with 14 legislative proposals to restrict or complicate access to voting. You know, back in October of 2019, we actually had bipartisan action in our Pennsylvania General Assembly when Republican and Democratic members of the General Assembly actually came together to overwhelmingly approve the no excuse mail-in ballot procedure. It proved to be very popular during the pandemic last year. I took advantage of it both in the primary and in the general election. But now Republicans in our General Assembly have proposed repealing the no excuses voting by mail. One wonders why. Proponents say it is about a loss of trust in the result of the last election. But others wonder if it is not more about a lost election. In the current issue of the Atlantic magazine, there is a cover story, an article titled, "When America Became a Democracy, the Voting Rights Act of 1965 finally delivered on the stated ideals of this country," that being the second founding, "but now it hangs by a thread." And the author writes, "Black Americans deserve better. Their struggle over the centuries helped create essentially all of the measures that we now associate with suffrage. The 14th and 15th Amendments, the 24th Amendment, the Voting Rights Act, the one person, one vote principle, and the 19th Amendment, which Black women helped with white women to secure. And was it not a Republican president who said the right to vote is the crown jewel of American liberties, and we will not see its luster diminished?" President Reagan was correct. And so I'd like to leave you with this thought to ponder. If every citizen does not enjoy access to vote, to the ability to vote, are we really a representative democracy? Is not the luster of American liberty not diminished in that case? I'll leave you with that thought, and I'll entertain any questions or comments. But thank you for listening.
Thank you very much, Don. That was great and illuminating. And I don't know what can we do?
Well, I think we have to remain vigilant. I think we have to remain vigilant. I've just written an article for the Bar Association. I know that some Democrats are thinking that President Biden needs to pack the court with nominees, and I don't think that's appropriate. I think it would only come with some trepidation. It would come with a lot of distraction away from what other more important, in my mind, agenda items that we're dealing with. I also think will only lead to retribution as parties change leadership. I would rather maybe make it a little tougher for judicial review, which is what happened here, is that the court reviewed an act of Congress and in effect, I think, imposed its own policy thinking. And I don't think that's the role of the Supreme Court, not when you have a record that was as developed as it was in this case. I mean, yes, the coverage formula hadn't been changed, but the evidence showed, very recent evidence was showing that the discrimination attempts that were still being made, my goodness, haven't we seen it since the Shelby County decision came down. So that's a possibility. The other possibility is I would very much like to see the John Lewis Act to advance voting passed and signed into law. I think we owe that to John Lewis and his many efforts, including, and really it was the incident and bloodshed that occurred at in Selma across the when he was leading the march across that bridge. That's what prompted LBJ and others to pass the Voting Rights Act in 1965.
Yeah. Does anybody have any questions? If you do, please unmute yourself.
Yeah, I would like to ask, this is Risa Mormantello. Thank you, Don, for a great review of all of that legal stuff. It's a fascinating history. One of my questions is why, if it's such an essential piece of our legislation, does it always have to be reauthorized every so many years? You said 7 years and then 25 years. Why isn't it just a permanent, staple of our law?
I think, I think you have to go back in time to 1965 and remember, Southern legislators still had a lot of control, and I think it wanted to be viewed as just a temporary, need. And then, they reviewed it in 1970 and then continuing. I think, but then it came to be 25 years, and I think it was because they thought progress was being made, and except in those particular areas. But it's a good question. But I think because they want change, they want these jurisdictions to improve. They don't want to saddle them with the responsibility. They could be trusted then to go forward without discrimination.
Okay, thank you.
Mary Jo, did you have a question?
I do. Is there any merit to the argument used by those who would like to repeal Act 77 that it is unconstitutional?
You'll have to help me here. Act 77 is?
Of Pennsylvania in October 2019, you had mentioned it.
Right, okay. I did not know it by that number, or if I did, no, I don't see how it could be deemed unconstitutional. I mean, the Constitution permits the legislature to set the rules for voting. The issue that, and if you've been paying attention, as I'm sure you have, the issue that was before the United States Supreme Court this week, and then they decided not to hear the case, was the fact that the Pennsylvania Supreme Court last year had said that ballots that were mailed by Election Day could still be reviewed if received within 3 days following the election. And the law had provided that the ballots had to be received by Election Day. But and I've only looked at this very briefly, but the record in that case that led to the Pennsylvania Supreme Court decision was the considerable delays that we were seeing, and I might add continue to see, with the Postal Service, and the fact that based upon the primary last year, the overwhelming number of mail-in ballots, and that election districts, election county offices around the Commonwealth all labored to deal with those ballots on a timely basis. The Pennsylvania Supreme Court is authorized by the Constitution to craft an appropriate remedy in case, in order to protect the exercise of the right of suffrage. And so it acted under that clause. And the request had been for 7 days, but the court thought 3 days would be enough. And that became the issue then, that at least the Republicans were taking up to the United States Supreme Court. And you probably realize too that was really the argument that was presented on January 6th by certain Republican senators to decertify Pennsylvania's vote, that the Pennsylvania Supreme Court, they didn't go into a big discussion of it, but the Supreme Court acted appropriately, based upon that language. Now you could say, well, it wasn't an appropriate remedy. The fact of the matter is, and what the Supreme Court in essence was told, and I think acted on this week, was if you take those ballots that came in and were considered for that 3-day period following the election, if you did not count them, they didn't make any difference in the outcome in Pennsylvania anyway. So I don't think that Act 77 will be deemed unconstitutional. And really, my take is that the Supreme Court made that interpretation because of the current situation with the Postal Service. I don't know going forward if that 3-day allowance will still be in effect or not.
Thank you.
Are there any other questions? So what do you think? I'm going to ask a question. Risa, do you have another question?
Yeah, just one quick thing. And I didn't want to take up other time for other questions, but since no one jumped in, you mentioned the two pieces of legislation that are currently being considered on the federal level, the John Lewis Act and the For the People Act. Do both of those need to be passed, in your opinion, to get the coverage we need for voting rights, or would one be preferable over the other?
Well, I think no. I think to really protect voting rights, both should be passed. I think we, and this gets into some other areas, but gerrymandering, has become a real. I think it's been a problem. When Berks County gets cut up into 4 different districts, and we don't even know who our congressperson is necessarily, and it's only being caused, the legislature has decided where the Republicans are. They want to pack the Republicans, or they want to pack the Democrats into certain districts, or they want to crack them, I think is the other phrase. Whereas, what the For the People Act is proposing, commissions would do that. A nonpartisan or bipartisan commission would do that. I think it's come time for that. So that's, and I really like, I don't know, I'd love to hear what other people feel. I really enjoyed being able to mail in my ballot instead of rushing to get home from work, at least back in the day when I worked, before the poll closed. Why do we need to have, why can't we have no excuse mail-in ballots? I mean, it doesn't make any sense to me. I don't think fraud, there was no, very few, if any, episodes of fraud dealing with the mail-in ballots. I think I heard of one episode, but so it would nationalize, at least for the federal elections.
Okay.
But the John Lewis Act, we definitely need that with regard to, as I indicated, the evidence of discrimination that has occurred since Shelby County. I mean, closing voting places, requiring voter ID, and then closing offices where you get that just astounds me. I mean, I don't know, it just astounds me.
Thank you.
Gary, did you have a question?
Yes, I go back to Senator Sheldon Whitehouse and the Coney Barrett confirmation hearing. And he went back through a 40-year history. I don't know if you're familiar with that particular, a 1-hour presentation, very similar to what you just did and what you've been doing in your programs, that there is an overwhelming support by the extremely wealthy people in this country to not let go. And by very careful positioning of people into places, including the courts, that the control is trying to keep the wealthy, the well-heeled in control of the country. And we're now suffering from some of those actions that White House presented. Do you have anything that you can add to my thoughts on that?
Well, I don't know that I see it as an income issue. I just see it as a partisanship issue. And, you know, the cynics out there will say, well, the Republicans weren't able to attract Hispanics, African Americans, people of color to the party. And so as a result of that, they want to then prevent them from voting or suppress their votes, limit their ability to vote. So I don't, you know, I don't want to, well, I suppose you all know where I stand ideologically, but I couldn't bring myself to watch that confirmation hearings. I was just so upset at the hypocrisy of Senator McConnell and Senator Lindsey Graham. I just couldn't bring myself to watch that. So I didn't see that history that you related, but I certainly, I would agree with you that it's the people in power that are attempting to stay in power. As some people would say, that it's the minority that's trying to dictate to the majority.
And through manipulation of things, whether they're legal or not, if they can, the idea was to, by little pieces, take things that over 100 years were put into place by, whether it was unions getting things into contracts, or whether it was taking away a protection for workers that came about through the last 100 or more years, whittling away little things so that the control could be maintained.
No, and I could cite you several Supreme Court decisions in which, you know, I would say that it's the conservative justices that are the activists and going into those areas, just as you said, campaign financing, labor unions, cutting back on those rights. And it used to be, you know, during the Nixon years, it was the liberals that were accused of being activists, and maybe they were to some extent. Active justices are not restricted to liberals or conservatives, but I think right now we're seeing with the court that we have activism, and it will be interesting to see the direction going forward. And just to you know, and I didn't really want to get into this either, but you know, the effort that was they did not pass it in time to get the issue on the ballot for our primary, but that is to change the way we elect justices to the Pennsylvania Supreme Court. We elect them at large, and not by, you know, the entire state. It's an at-large election, and currently the Democrats have a slight edge on the court. But the Republicans in the General Assembly, several of them have proposed changing it to a district election, and so that in their mind to increase the representation of the more rural areas, as opposed to just having justices from either Philadelphia or Pittsburgh or the Harrisburg area. The problem is, from the viewpoint of others, that how they draw those districts will be done on partisan lines, and you know, packing Republicans in certain districts and limiting Democrats to other districts. So it's a concern. That's an example of trying now to even further politicize the Pennsylvania Supreme Court, when really it it really should be just simply a matter of calling balls and strikes, um, instead of what does my party want me to do.
But as I wrote in my letter to the editor, we would go from voting for 31 justices or judges over a 10-year period to voting for 3. I
Mhm.
can't think of anything of a more suppression of voting rights than that stupidity. What was that, House Bill 38?
Yeah, I'm not good with numbers.
I think it was
I think
38.
it is 38.
Well, thank you for expressing your opinion and taking the time to write a letter to the editor, and thank you for taking time to be part of this program.
Okay, I
Enjoy.
have one last question. And that is, do you think that every state needs a Stacey Abrams? And if you do, how do we get them?
Wouldn't that be great? And I don't mean that because she's a Democrat. I just think it's neat. And you know, and everything that I've said, we had such a great voter turnout this last November, and of course, a large part of that was the mail-in ballots. But yeah, I mean, I wish we all would be that involved. I mean, voter turnout in the past has been way too low. I mean, we
Yeah,
need to take it seriously, our responsibilities as citizens.
yeah. And especially in years like this, which is a local primary election year, that people tend to just say, I only vote for president.
And
They
that's a
need
shame
people.
because, as you know, we have 2 openings on our court common pleas bench.
That's right, yeah,
And that's such an important election.
yeah. And there are openings on the Reading School Board and on other school boards. There are openings on city council in Reading. There are openings all over the county. So people have to get out and vote and register. Register first and then vote. That's my thing. Anybody else have questions? Okay, I want to thank you all
Yes,
for
thank you.
joining this discussion. And thank you, Don. This was great, as usual. I'll be calling you.
Thank you.
You're welcome. Thank you.
Thank you.
Okay, thanks. Have a good night.
Okay, you too.